Okay, so A2 law students, your assessment question was on Adrian and Ben, and this was from a January 2012 question paper. Now, the first question was discuss the possible criminal liability of Adrian for the injuries to Ben for 25 marks plus 5 marks for AO3. Now, the key points I'm hoping that you picked up were that they'd been at home watching a cage fighting martial arts DVD, having spent all morning drinking beer and whiskey. They agreed to a fight, they would try to copy the moves they'd been watching. Adrian succeeded in securing an arm lock on Ben, who indicated to Adrian that he accepted defeat. However, Adrian continued to apply pressure and Ben's arm was broken. The break, though relatively minor, later became a great deal worse, with a permanent restriction in movement when Ben's arm was further damaged due to poor medical treatment at the hospital. So the key points there that you ought to have picked up were the drinking beer and whiskey all morning, the agreement to a fight, which shows you that you would be talking about consent, Adrian succeeding in securing an arm lock, but Ben then indicates defeat, but Adrian continues to apply pressure, so he no longer has consent at this point, and that the break was relatively minor at that point, but became worse after poor medical treatment. Now, the question that you had to look at first was discuss the possible criminal liability of Adrian for the injuries to Ben, and we're going to look at the key components that you should find in your answer. Okay, so take a look at the screen. The sidebars in pink are just indicators of information. Doesn't mean you'll be writing about all those information. We're going to look at the information in the white area here. So in breaking Ben's arm, Adrian may have caused actual bodily harm. I'm hoping nobody started with a section 39 of the Criminal Justice Act. So your starting point should be section 47. That's your identification of the issue. Now, in your definition, you should be providing information about the actus reus and the mens rea, and in your explanation, you should be providing key points about the area of actual bodily harm. Now, you can find this in this information. When you look through your information, you may find that it's in slightly different places within one paragraph. But by reading through, you should be able to locate the key things. So, for example, I should be able to find both the actus reus and the mens rea. The actus reus of a section 47 is evidence of an assault or battery which causes ABH. So make sure that you pause this video and look for the words evidence or proof of an assault or battery which causes actual bodily harm. And the mens rea is intention or subjective recklessness as to causing fear of unlawful violence or of applying unlawful force. Now, information that explains this section further are things like actual bodily harm means any hurt or injury calculated to interfere with the health and comfort of the victim. This comes from Miller. Liability for section 47 is constructive. This means that it's built out of or constructed from the lesser offence. Now, the lesser offence is, of course, section 39. Okay, and the only difference between a section 47 and common assault is the causing of some bodily harm. And remember, bodily harm doesn't have to be bodily harm, it can be psychological. Okay, I'm going to jump a bit to the additional injury. Now, you should also find that this answer should have covered section 20. The additional injury by way of permanent restriction in movement almost certainly is GBH, and this would come under section 20 of the Offences Against the Persons Act 1861. So please locate that in the answer. That should be there, whether you are peer marking or self-assessing. Make sure you have the correct year. If you do abbreviate like this, always make sure you set it in full first. Now the actus reus of a section 20 is that you would have covered the words wounding or inflicting GBH. Okay, so there is a wound or the infliction of GBH. The mens rea is if the defendant intended or foresaw some harm. Intended or foresaw some harm. Even, it doesn't have to be serious harm. Savage and Parmenter are your key cases. The actual harm that happened doesn't have to be intended or foreseen. Or we can show that the defendant was reckless as to whether some injury would be inflicted. Now you can see in this answer here that we've got that information there. That the defendant intended to do some harm, or that the defendant foresaw that some harm might be done, and yet went on anyway, so cunning and recklessness. Okay. The defendant doesn't have to foresee the actual wound or GBH. It's just so long as they know some harm could have happened. Application in terms of mens rea, Adrian intended to apply force to Ben in the initial arm lock. Now that's sufficient mens rea because we know that there was intention to begin with. Okay, it's possible that Adrian committed GBH, and we've got that information here repeated again. The mens rea would be the intention to cause some harm. When Adrian continued to apply pressure, there was certainly evidence of intention or recklessness as to some harm. If Adrian could be shown to have intended serious injury, then the offence could be the more serious one under the Offences Against the Persons Act, Section 18. But we know that due to the drinking, it's impossible for us to actually show a Section 18, so it's just a brief mention of it. For this first question, we also would have had to cover consent. Okay, so consent is the relevant defence. So we've identified the defence, and remember, you only cover defences after you've covered any offences. Now, even though we are going to look at consent, I've just realised that I have forgotten to cover a very key point because I was jumping around the screen here. And before we even get to the defence, you may have noticed that I didn't cover causation. And causation is a very important part of this question because of the fact that with Adrian's action, there's only a minor injury to Ben, but it's due to poor medical treatment at the hospital that Ben is left with a permanent restriction in movement. So we know we're going to cover causation. Adrian may argue that though he's the factual cause and the legal cause, the chain of causation has in fact been broken by the hospital's poor medical treatment. And this is important. So we've got coverage of causation. It's an identified issue. Here is a sentence that just describes what causation is. It's the link between the defendant's act and the end result. But for Adrian's conduct, Ben would not now have a permanent restriction in the movement of his arm. So Adrian is the factual cause, White being a key case, in brackets, no need for the facts. Legal causation requires him to be more than a minimal cause, and there's evidence of both factual and legal causation. Now, even though this is the case, he may argue that the chain of causation has been broken by an intervening act, namely poor medical treatment. Key cases here are Smith and Cheshire. Okay, given that the treatment is directed at the injury and not independent, it is unlikely that Adrian will escape liability. The additional injury by way of permanent restriction in movement almost certainly amounted to GBH. Okay. And then before we actually leave this section, please remember that in the GBH coverage that both wound and serious injury have been covered and supported for a good answer. Let's move now to consent. And remember, this is just an overview of this answer because you have a copy of this with you in paper format. So you've got a hard copy as well as this explanation via this recording. So when it comes to consent, the general rule is that no liability is incurred if a person inflicts minor harm with the consent of the victim. Now, consent operates as a defence because the courts do recognise that we have a freedom of choice over our own lives, about what we choose to do and don't choose to do, but there are limits to what we can consent to. Now, consent can be available as a defence to common assault and battery, but it's not available for more serious offences. And you can see that that's written there in the bold. Okay, so the general rule is there can be no consent to injury amounting at least to actual bodily harm, and no consent to injury inflicted in the course of unregulated fights. But there are a number of public policy exceptions. Now, since their fight would not be classed as a fight at all, but rather as rough, undisciplined play, Adrian could try to argue that he had Ben's consent. However, this would clearly apply to the initial stages of the incident because we know that later Ben actually withdrew his consent. Unless, however, what we're going to say is because they've been drinking all morning, Ben was too drunk to actually give consent, and that's a possibility. But what we do know is that he did withdraw his consent later, when he accepted defeat. So the defence of consent could no longer apply once Ben had withdrawn consent. Okay, let's move on now to the next defence, which is intoxication, because they've been drinking all morning. Now, the defence of intoxication requires us to define it, explain it, make sure we've talked about voluntary intoxication and involuntary intoxication, basic intent crimes and specific intent crimes. The defence requires evidence that Adrian was incapable of forming and didn't form the necessary intent. Now, on the basis of the Majowski case, voluntary intoxication can be a defence to crimes of specific intent, but not crimes of basic intent. Now, both Section 47 and Section 20 are both basic intent crimes, so Adrian would not be able to escape liability on the grounds of his self-induced intoxication. If the charge, however, had been for a Section 18, he might have been able to successfully plead intoxication and had his charge substituted with a basic intent equivalent, such as a Section 20, but this isn't the case here. So his liability, therefore, will be imposed on the basis that he was reckless in becoming intoxicated, and recklessness is enough mens rea in respect of any of the basic intent offences. Okay, now that is coverage of that first part of the question, which was discuss the possible criminal liability of Adrian for the injuries to Ben. On your hard copy, you will have suggested marks for both sections. Please look through the answer, whether peer marking or self-assessing, and use your judgment. You've also got your tables where you've got the breakdown of the actus reus, the mens rea, the types of injury, relevant cases. It is very important that you start to become very independent in your learning and that you're able to do as many examination questions as possible, because this will be a very, very important feature of you gaining high grade marks in the summer exam. I'm going to leave this as a single recording dealing with that first section, discuss the possible criminal liability of Adrian for the injuries to Ben. The second recording will discuss the actual content for that second part, which is discuss the possible criminal liability of Adrian arising out of his conduct in relation to Charles and to Dora, and to discuss the possible criminal liability of Emma for her conduct in relation to George, which is 25 marks.